Hi guys, welcome to another episode of Attorney Javier Law Vlog. Today we continue with our discussion on the Intellectual Property Code, and specifically for today we'll begin with the topic of copyrights. Now if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now, a like on this video or any of my other videos would also be greatly appreciated. Now, you can also find me on Alex at www.alexlegal.ph. Alex is an online directory of lawyers which makes it easy for people like you to connect with lawyers like me for legal assistance from the convenience of your mobile phones, laptops, or tablets. I will insert a link to my profile in the description below so that you can easily reach out or schedule an appointment with me. Okay, just check the description below. Now, the law on copyright is found in the Intellectual Property Code, which is Republic Act number 8293 as amended. Being an intellectual creation, it is a mode of acquiring ownership. Now, what is a copyright? A copyright is an intangible incorporeal right to certain literary, scholarly, scientific, and artistic productions which is granted by law to the author or creator of the work. It is an original intellectual creation and it is protected from the moment that it is created. Okay? This is very important. A copyright, the work subject of the copyright is protected from the moment of its creation. Take note that the copyright is different from the property in the material object subject of the copyright. Okay? What works are protected by a copyright? In general, we have two. We have the original and we have the derivative works. Original works are literary and artistic works which are protected from the moment of their creation, irrespective of the mode or form of expression of their content, quality, or purpose. So the law gives a very long list, which gives us some examples, but of course the list is not exclusive. Some examples are books, articles, newspapers, lectures, sermons, dissertations, letters, dramatic or musical compositions, choreographic works like dancing, illustrations, ornamental designs, drawings, maps, sketches, cinematographic works or films, advertisements, computer programs, and other literary, scholarly, scientific, and artistic works. However, while that list is not exclusive, take note of the case of Pearl versus Schumart, where a copyright was filed for advertising light boxes. If you're my age, you would have reached this advertising light boxes in cinemas, where there is a poster within a box that is lit up, so that it seems that it is illuminated. Okay. So, the copyright was filed for these advertising light boxes by its inventor, which is Pearl and Dean. And Pearl and Dean, as the inventor, it leased out those light boxes to SM. However, SM Schumart engaged other entities to create light boxes for the use of SM. So, of course, Pearl sued SM for infringement. And the Supreme Court ruled in favor of SM, okay, SM won, saying that a copyright is a purely statutory right or a right granted by law. And therefore, the rights granted are limited to what the law gives. As such, the copyright of Pearl over the light boxes extended only to the technical drawings over the light boxes and not to the box itself, because the box itself is not a literary or artistic piece. Pearl would have succeeded in the infringement case if what SM had done was to reprint the technical drawings without Pearl's consent. Okay, in order for Pearl to have protected itself with regard to the boxes, what Pearl should have done instead of securing a copyright was to secure a patent over that invention, which unfortunately they did not. They secured a copyright, and that's why they lost in this case. Please just read the case to understand it better, okay? Now, that's for original works. As for derivative works, these are works, as from the name itself, they are derived from an original. And they include dramatizations, no? You dramatize the original. Translations, you translate it, no? Adaptations, abridgments, arrangements, and other alterations of the literary or artistic works. And derivative works also include collections of literary, scholarly, or artistic works. They also include compilations of data and other materials which are original by reason of their selection or coordination or arrangement of their contents. Okay? So the law under Section 175 also states what works are not protected. Okay? Take note of this list. It's also very long. The first work that is not protected would be any idea, procedure, system, method, or operation, concept, principle, discovery, or mere data as such, even if they are expressed, explained, illustrated, or embodied in a work. Okay, just an idea, that's not copyrightable, no? Or just a principle, that's not copyrightable. Another work that is not protected would be news of the day. Okay? News of the day or other miscellaneous facts having the character of mere items of press information. Another work that is not protected would be any official text of a legislative, administrative, or legal nature, as well as any official translation thereof. Okay, so there can be no copyright over the law, no? Like this, the law on copyrights, RA 8293. Okay, you cannot copyright that. Also, under Section 176, no copyright shall subsist in any work of the government of the Philippines. However, even if there can be no copyright over any government work, in case that government work will be exploited for profit, then you have to get the approval of the appropriate government agency or office. Of course, no approval is necessary for the use in any purpose of statutes or laws, rules or regulations, speeches, lectures, whether given in court or in Congress, okay? But take note that the author of those speeches, no, in Congress or in court, that author is given the exclusive right to make a collection of his work. Okay, so he has the exclusive right to collect all the speeches he has ever made and publish them into a book or a video if he wants. Okay, that said, even though there can be no copyright in government work, the government may still receive and hold copyrights over different matter which may be transferred to it by assignment or other modes of transfer. So government work by itself is not copyrightable, but the government can hold copyrights over other things. So a copyright is protected from the moment of its creation, okay, from the creation of the work. And what is the scope of the protection? A copyright gives protection to the author of the work and his heirs by punishing infringement, which we'll talk about in the next video, and by giving certain economic and moral rights. So let's begin with the economic rights. Economic rights consist of the exclusive rights to carry out, authorize, or prevent the following acts. Okay, economic rights meaning something you derive money from. Okay, so they have the exclusive rights to carry out the following. First, the reproduction of the work or a substantial portion of the work. Okay, so if you have the copyright over, let's say, a book, you have the exclusive right to have it reproduced, or even just a portion of that book to have it reproduced. Second, dramatization, translation, adaptation, abridgment, arrangement, or other transformation of the work. Okay? That's the second economic right. Third, the first public distribution of the original and each copy of the work by sale or other forms of transfer of ownership. Fourth, rental of the original or a copy of an audiovisual or cinematographic work, a work embodied in a sound recording, a computer program, a compilation of data and other materials, or even a musical work in graphic form. Okay, meaning those notes, no, on the tab. Okay, irrespective of the ownership of the original or the copy, which is the subject of the renewal. Fifth, okay, one of the economic rights is the exclusive right to carry out a public display of the original or a copy of the work. Sixth, to carry out a public performance of the work. And seventh, other communication to the public of the work. So in general, these rights exist during the lifetime of the author and for 50 years after his death. Okay? Further, the law grants the author a right to receive proceeds in subsequent transfers of the work. Okay? So let's say he makes a first transfer and then the transferee transfers it again and again and again. The author still is given the right to receive proceeds from those subsequent transfers. And this right is known as the droit de suite. Okay? Under Section 200, the author or his heirs shall have an inalienable right to receive 5% of the gross proceeds of the subsequent sale or lease of the work, which right shall exist during the lifetime of the author and for 50 years after his death. However, take note, no, this is the exception. The rule shall not apply to prints, etchings, engravings, works of applied art, or works of similar kind where the author primarily derives gain from the proceeds of reproductions. Okay? Now we can move on to the moral rights. And when we say moral rights, the author, even if he assigns or licenses the work, the author still has or retains the following rights. First, the right to require that the authorship of the works be attributed to him. Okay? He can require the licensee or the holder, hey, you have to state my name, that work is made by me. Okay? In particular, the right that his name, as far as practicable, be indicated in a prominent way on the copies and in connection with the public use of his work. And this is the only moral right that shall last not only during the lifetime of the author, but also in perpetuity after his death. So may forever. Okay? Now, the following moral rights are coterminous with the economic rights. Coterminous meaning that during the lifetime of the author and for 50 years after his death. Okay? The following. First, to make any alterations of his work prior to or to withhold it from publication. Second, to object to any distortion, mutilation, or other modification of or other derogatory action in relation to his work which would be prejudicial to his honor and reputation. And third, to restrain the use of his name with respect to any work that is not of his own creation or in a distorted version of his work. Take note that while economic rights may be transferred or assigned or subject to license, moral rights cannot be assigned or be subject of a license. These moral rights stick with the author. Okay, the author retains them even though he may have assigned the economic rights or transferred the economic rights. So, who owns the copyright? Okay, how long does the copyright last? Okay, it depends on the nature of the work. First, for original and artistic works, the author owns the copyright, and the copyright shall last during the life of the author and for 50 years after his death, meaning that the heirs can enjoy the rights after the author dies. Posthumous works, or works that are after the death of the author, are also protected for the same period. And the term of protection subsequent to publication or death shall be deemed to begin on January 1 of the year following the event which gave rise to them, meaning publication or death. Okay? Second, in case of works of joint ownership, okay, the co-authors shall be the original owners of the copyright. Of course, if there is an agreement, you follow the agreement, okay? And in the absence of an agreement, the rights shall be governed by the rules on co-ownership. If a work of joint ownership consists of parts that can be used separately and the author of each part can be identified, then the author of each part shall be the original owner of the copyright in the part that he has created. If these economic rights shall be protected during the life of the last surviving author and for 50 years after his death. Okay? Now, for work created by an author during and in the course of his employment, okay, these are the rules to whom the copyright shall belong. If the creation of the object of the copyright, the thing itself, if the creation of the object is not part of the regular duties, even if the employee uses the time, facilities, and materials of the employer, then the employee or the creator is the owner of the copyright, okay? But if the work is a result of the performance of his regularly assigned duties, then the employer is the owner, unless there is an agreement, express or implied, to the contrary. So check first, as always, if there is an agreement. Now, what about work which is commissioned by a person other than the employer of the author and who pays for it, and the work is made in pursuance of the commission? Then, the person who so commissioned the work shall have ownership of the work, the object itself, but the copyright shall remain with the creator, unless there is a written stipulation to the contrary. Okay? Now, what about audiovisual work? Okay? Audiovisual, no? The copyright shall belong to the producer, the author of the scenario, the composer of the music, the film director, and the author of the work so adapted. Okay? Meaning the original. So all these people own that audiovisual work. Okay? The producer shall exercise the copyright to an extent required for the exhibition of the work in any manner, except for the right to collect performing license fees for the performance of musical compositions with or without words, which are incorporated into the work, unless, of course, there are contrary or other stipulations among the creators, meaning that the creators can make different agreements. The term shall be 50 years from the date of publication, and if it's unpublished, from the date of the making. What about letters and private communications, no? Which are in writing, of course. Let's say love letters, those are included. Now, these letters are owned by the person to whom they are addressed. So, if a lover sends a letter to his girlfriend, then the girlfriend owns those letters. But these letters cannot be published or disseminated without the consent of the writer or his heirs. However, the court may authorize their publication or dissemination if the public good or the interest of justice so requires. What about anonymous and pseudonymous works? Okay, or when we say anonymous, you don't know who the author is, or pseudonymous works, meaning those works written by an author using a different name. Okay? Publishers shall be deemed to represent the authors of articles and other writings published without the names of the authors or under pseudonyms, unless the contrary appears or the pseudonyms or adopted name leaves no doubt as to the author's identity, or if the author of the anonymous works discloses his identity. He reveals himself as, hey, I am really XYZ author, okay? So, the copyright shall be protected for 50 years from the date on which the work was first lawfully published. In case the author's identity is revealed or is no longer in doubt before the 50-year period expires, the copyright shall be protected during the life of the author and for 50 years after his death or the death of the last surviving author. In case of posthumous, anonymous, or pseudonymous works, meaning anonymous or pseudonymous works that were published after the death of the author, then they shall be protected for 50 years counted from the making of the work. Okay? So what about works of applied art? The protection shall be for a period of 25 years from the date of making. As for photographic works, the protection shall be from 50 years from the publication of the work and, if unpublished, 50 years from the making. What about performances which are not incorporated in recordings? Then 50 years from the end of the year in which the performance took place. For sound or image and sound recordings and for performance incorporated in such recordings, they are protected for 50 years from the end of the year in which the recording took place. And finally, in case of broadcasts, the term shall be for 20 years from the date that the broadcast took place. Now, the law grants specific economic rights to performers, producers of sound recordings, and broadcasting organizations. These are known as the neighboring or related rights. Okay? First, for performers. Actors, singers, musicians, dancers, and other persons who act, sing, declaim, play in, interpret, or otherwise perform literary and artistic work. Okay? First, as regarding their performance, the right authorizing the broadcasting or other communication or transmission to the public of their performance, and the fixation, meaning the embodiment of sounds or the representations thereof from which they can be perceived, reproduced, or communicated through a device or of their unfixed performance. These rights shall be maintained and exercised 50 years after their death by their heirs, and in default of heirs, the government where the protection is claimed. Okay? Again, for performance, they have the right to authorize broadcasting and the embodiment of what they made into a recording. Okay? That lasts for 50 years. Next, the right of authorizing the direct or indirect reproduction of their performances fixed in sound recordings or audiovisual works or fixations in any manner or form. The next right, the right of authorizing the first public distribution of the original and copies of their performance fixed in recordings, okay? Or fixations through sale or rental or other forms of transfer. Subject, of course, to the right to receive additional remuneration. And in case the additional remuneration is not agreed upon, then the law says they shall receive at least 5% of the original compensation received for the first communication. Okay? Next right, the right of authorizing the commercial rental to the public of the original and copies of the performances which are fixed in recordings. Okay? And the last, the right of authorizing the making available to the public of their performances which are fixed in recordings. Okay? So performers also have the moral right with regard to their live oral performances, no, oral AU, no, meaning auditory, or performances which are fixed in sound recordings or in audiovisual works or fixations to claim to be identified as the performer. No credits, no, they should be listed in the credits, and to object to any distortion, mutilation, or other modification of their performances. In short, they can say, wag mong babuyin yung ginawa kong performance. Okay? So that's for performers. Those are the neighboring or related rights. As for producers of sound recordings, they also have neighboring and related rights, or related rights, no? So, the person or the legal entity who or which takes the initiative and has the responsibility for the first fixation of the sounds of a performance or the representation of such sounds, they have the following rights. First, the following neighboring or associated rights. Now, first, the right to authorize the direct or indirect reproduction of their sound recordings in any manner or form, no? Meaning the placing of these reproductions in the market and the right of rental or lending. Next right is to authorize the first public distribution of the original and copies of their sound recordings through sale or rental, no? Next right, to authorize the commercial rental to the public of the original and copies of their sound recordings even after distribution by them or pursuant to authorization by the producer. And last, the right to authorize the making available to the public of their sound recordings in such a way that members of the public may access the sound recording from a place and a time individually chosen or selected by them, as well as other transmissions of a sound recording with like effect. Okay, and the last class which has neighboring rights would be broadcasting organizations, which may refer to a natural person or a juridical entity which is duly organized to engage in broadcasting. So they can enjoy the exclusive right to carry out, authorize, or prevent any of the following acts. First, the rebroadcasting of their broadcasts. Okay, they can carry that out or they can prevent it, no? Second, the recording in any manner, including the making of films or the use of videotape of their broadcasts for the purpose of communication to the public. And the use of such records for fresh transmissions or for fresh recording. So take note that a literary, artistic, or scholarly work is already protected from the moment of its creation. However, for additional protection, the law provides for the procedure of registration. Take note that registration is not necessary to protect the work, as the copyright again exists from the moment of creation. For registration, Section 191 gives us the rule. At any time during the subsistence of the copyright, the owner of the copyright or of any exclusive right in the work may, for the purpose of completing the records of the National Library and the Supreme Court Library, they may register and deposit with those libraries by personal delivery or by registered mail 2 complete copies or reproductions of the work in such form as may be prescribed by the libraries. Okay? Take note, no, I mentioned Supreme Court Library, but you only register there if it pertains to a work in the field of law. Okay? Otherwise, everything else goes to the National Library. Now, again, registration is not required. Okay? Registration and deposit with the library is not a condition of copyright protection, and this is recognized in the website of the Intellectual Property Office, which says that recordation or deposit of your works is not necessary, but authors and artists may opt to execute an affidavit of ownership with the National Library or the Intellectual Property Office for the issuance of recordation and deposit. Okay, you can check out their website at ipofil.gov.ph. I'll put it in the description below, okay, in order to register your copyright online. And they have instructions there, so it should be no problem at all. So if registration is not necessary to protect the copyright, what's the use? Well, aside from serving as evidence of the copyright, okay, it also facilitates enforcement of the copyright after the author or the creator has died. Under Section 198, the persons to be charged with the posthumous enforcement of copyrights shall be named in a written instrument which shall be filed with the National Library. And in their default, the enforcement will devolve upon the author's heirs, and in default of the heirs, again, the director of the National Library. So how do we know that a copyright exists? Well, Section 192 states that each copy of a work published or offered for sale may contain a notice bearing the name of the copyright owner and the year of its first publication, and in copies produced after the creator's death, then the year of such death. Since the law uses the word may, the notice is not mandatory. However, take note that it is preferable. No? You would want to protect yourself in any way you can. Now, the law allows the owner of a copyright to transfer, assign, and license the copyright. Section 180.1 states that the copyright may be assigned or licensed in whole or even in part. Okay? Within the scope of the assignment or license, the assignee or licensee is entitled to all the rights and remedies which the assigner or licensor had with respect to the contract, and this licensing or assignment must be written, and the copyright owner has a right to regular statements of account. Okay? The assignment or license may be filed with the National Library. Now, in case of a submission of a literary, photographic, or artistic work to a newspaper, magazine, or periodical for publication, that shall constitute only a license to make a single publication, unless a greater right is expressly granted. No? So the parties can agree for a greater scope, no, in their agreement. Now, if two or more persons jointly own a copyright or any part thereof, neither of the owners shall be entitled to grant licenses without the prior written consent of the other owner, no? Because you jointly own it. Okay, you have to get the consent of the other person. Now, I mentioned earlier that the copyright is distinct from the object or work subject of the copyright. Consequently, the transfer, assignment, or licensing of the copyright shall not by itself constitute a transfer of the material object. Kasi nga, magkahiwalay. Nor shall a transfer or assignment of the sole copy or one or several copies of the work that will not imply transfer, assignment, or licensing of the copyright. Okay? So, again, I discussed the rights and the duration of those rights and the procedure for registration, no? In the next episode, I'll be talking about infringement or the violation of the rights that I just discussed, okay? So, I hope you may have picked up a thing or two, and I hope to see you next time, guys, okay? See you soon. Bye.